we're moving now from economics to social, more social aspects of development and integration. And Professor Susan Farran's presentation, as I read it, it reminded me of the 1990s and the noughties, as I sat in a traffic jam on a motorway, listening to the radio and being told that the economy had grown by 8% this year and the country was going great. But I was sitting in a traffic jam and my quality of life was on the way down. Everybody was working very hard. And all in all, the price of the Americano was going through the roof. The price of houses was skyrocketing, and I knew that my children were going to have to, instead of paying back 200,000 to the bank in interest on their lifetime, they'd have to pay back 2 million to the bank in interest on their lifetime. So there's a disconnect between social well-being and economic growth unless it's properly managed very often. This is an area, perhaps not exactly what Professor Farran is working on, but she's the Professor of Laws at Northumbria University Law School, an adjunct professor of the University of South Pacific, and an associate of the Centre of Pacific Studies. And her presentation is the impact of development on social, cultural, and human rights, including children's rights.
Thank you. Thank you very much to the organisers for inviting me. I know nothing about arbitration. I'm not a practicing lawyer, and I'm an academic. But I'm going to talk about intellectual property, which actually ties in quite well with some of the stuff that's already been talked about, particularly the WTO, of course, but also PACER Plus from this morning and various other trade treaties. The reason why I got interested in this particular topic, my area of research is the Pacific Islands, resulting from a period of being at the University of the South Pacific in Vanuatu. And for the last 4 years, I've been working with a colleague at the Australian National University, looking at intellectual property in the Pacific region, and we're looking particularly at traditional knowledge and intellectual property, and published last year a book entitled Weaving Intellectual Property Policy for Development. You see, I can do my own promotions as well. And one of the things that we learned very much was what happens on the ground in terms of intellectual property laws. And the region has seen, I think, two probably conflicting directions in recent decades. The first is development, rapid development, economic development and social development, with quite a lot of trade treaty negotiations going on. Not always, I might say, very successful. The second is a growing awareness of the value of traditional knowledge and traditional cultural expression as a valuable cultural heritage on the one hand that needs protecting, but also with potential for economic growth. Cultural industries are becoming a bit of a sexy word in the Pacific, the development of cultural industries for economic growth. Now, the type of regulatory frameworks that you need to both protect and promote are not necessarily the same. I'll just skip over this because lots of people have talked about small island states. I was just interested in informing my own research as how the Pacific Islands compared with Iceland and Liechtenstein. And in fact, it's quite interesting when you take different criteria or different data, you've either got a small state or you haven't got a small state, which I think is really important to bear in mind. And these variables are very influential in terms of both trade and the efficacy of any legal system, including laws on intellectual property and the arbitration or the dispute resolution of trade deals. So the regime of intellectual property within the Pacific Island countries, and here I'm talking about those Pacific Island countries that came under the influence of the common law rather than the French civil law or Spanish law, is a mix. We have plural legal systems in the Pacific Island countries, formal and informal law. So quite a lot of very basic intellectual property law was introduced under colonial rule, derived from the metropolitan powers. So you find legislation on the standard patents, copyrights, trademarks. There's also increasingly today national laws, originally very much modelled on the Western liberal idea of intellectual property, which had very little meaning in Pacific Islands. There's not much point in having laws about patents when you have no research centres. You have very little industrialisation, very little manufacturing base. But what you find in the years immediately after independence of the various Pacific Island states is that Western-style intellectual property laws are adopted. What has happened since 2000 has been the passing of national laws with a slightly more encompassing scope to try and incorporate some of those forms of intellectual property, and I use that term in inverted commas because I don't think that everybody sees intellectual property in the same way, to include things like folklore, cultural rights, and plant breeders' rights. So, if you like, a legislative attempt to straddle the divide between traditional knowledge and cultural expression, dances, costume, song, medicinal knowledge, agricultural and fishing knowledge, maritime knowledge in particular, and the intellectual property that emerging economies and the developed world are familiar with, copyright for artists, for musicians, and that type of thing. So there has been this attempt to straddle at national level. Not always very successful, because what you find when you look at this legislation is that there's an attempt to straitjacket traditional knowledge within the legal language of Western intellectual property. So, for example, to talk about ownership, it doesn't work when you're not talking about the same concept. The word may sound the same, but the interpretation may well be different. And then, of course, there's international treaties and conventions, and I've listed some there. You'll see that not a great many countries are necessarily signed up to international conventions, and these conventions have no effect in domestic law until they are incorporated into domestic law. So, as has been mentioned, countries may well sign up to all manner of international treaties and conventions, and they are really fairly meaningless, but they tick the box. What are the challenges of the intellectual property law regimes that have been brought in, particularly regimes that have been brought in to comply with WTO compliance under TRIPS? 2 countries have recently joined the WTO, Samoa and Vanuatu, Tonga in 2007. Other countries were members of GATT and became members of the WTO that way. Under TRIPS, as you probably know, there's the requirement to put into place TRIPS compliance legislation, so there's been activity there. But there are real problems in terms of resources and human skills in enforcing intellectual property laws. For example, copyright is probably the most relevant intellectual property law in the region, and yet island countries have struggled to both put in place intellectual property offices and to enforce the law. I think in Fiji there's been a number of cases brought, only 2 have been successful prosecutions. In Vanuatu there's been an intellectual property office established, but for a long time it was really the first person who was in post really struggled to come to grips with the scope of the task. And when there has been an attempt to register copyright, for example, about performances, there has been quite a lot of litigation ensuing. So there aren't the resources for enforcement. the underpinning legal concepts behind intellectual property law are alien. They are transplants. For example, in the Pacific, it may be very difficult to pinpoint when a design started, when medicinal knowledge originated. These things in custom are exchanged. They may be surrounded by secrecy. There may be certain taboos or prohibitions regarding their use, regarding their transfer, regarding the performance or whatever. And the idea that you can pinpoint who came up with that idea which manifested itself in a particular way at a particular time really creates a lot of problems. Even if you have collective intellectual property rights, the difficulty, and this has been encountered with extractive industries, is what is the collective? What is the community? People may say they belong to this particular group, but they may also belong to another particular group, to their uncle or mother or aunt or father. So the affiliation of people is not ring-fenced. It's fluid. And that can create real problems in deciding who are the owners, who should benefit from any economic return on an intellectual property. There are also very conflicting views in developing economies as to whether it's good or bad to have intellectual property rights. Emerging artists, young musicians want to have their work copyrighted, even if they've borrowed the ideas over the internet or YouTube or copied bits of tune from something that they've heard elsewhere. Educationalists, on the other hand, may not want strict copyright because if you have books that are copyrighted, it makes them expensive for school children. It makes it expensive for university students. University students don't want software copyrighted because then they can't share. And so there are all sorts of different agendas in play about whether you have strong or weak intellectual property laws. There's also the question of relevance, particularly in case of patents. There is no pharmaceutical industry in the Pacific. There's some agro industry in terms of agricultural research, but most of the research that goes into agrochemicals, plants, pharmaceuticals doesn't occur in the developing world. It doesn't occur in the Pacific. Very little of it occurs in small states. It occurs in Europe and in America. And so the relevance of those sort of things is really quite questionable. There's also a number of restrictions and exceptions within the domestic law that makes it difficult. I'll give you an example of something you're maybe familiar with. The producers of Fiji water, which you can buy in London, are prohibited by law, a decree, in the days when Fiji was not a democracy, which was fairly recently, that Fiji cannot be used as a geographical indicator on a product. So you can trademark Fiji water, although there has been a case in the US court about the Fiji trademark, but you cannot call something Fiji water as a geographical indicator. Now, from the point of view of trade, if you think of geographical indicators with which you're familiar, like Parma ham, the Pacific is a tiny area, and so the selling point of a product is likely to be a geographical indicator to tell you that it comes from that small state. If you've got prohibitions, it makes it rather less attractive. And as I say, this problem of trying to straddle two worlds in one law, traditional property, traditional knowledge, and non-traditional knowledge, is an issue. And so I think that it's all very well to talk about rules and laws from the global north and imposing them on the global south. But in practice, there are real challenges in making these work. And I think, although it might be a blasphemy in a law firm's building to say this, that the law by itself may not always be a panacea, or a particular law may not be a panacea. And it's important to think around the problem. So one of the things that can be used, and it's been mentioned, is much stronger use of contract law. and making sure that the parties to both sides of a contract understand, not just by using the same words, but by understanding the concepts behind the words, what it is that they're agreeing to. There's no customs union in the Pacific. So if you want to stop goods moving or being pirated, then something needs to be done about improving the customs regimes. Or if you don't want plant material, drawing on the biodiversity of the region, to leave the region without consent or without control, then, as happens in Australia, for example, you need much stronger quarantine and custom laws. Just to give you a final example of a non-law approach that actually worked very well, naming, shaming, and educating. This draws on traditional controls of knowledge and intellectual property, but some of you may be aware that Nike produced a range of very tight-fitting ladies' sportswear that was embellished with patterns drawn from the Samoan tattoo. And there was an outcry, both in Samoa itself and among the diaspora of Samoa, about this totally inappropriate use of this male tattoo pattern that was printed onto clothes to be worn by females, close-fitting clothes, very contrary to the type of costume that is approved of in Samoa. And actually, through social media and through the press, Nike had to apologize. Now, there was no issue about claiming intellectual property rights. Nike apologized, withdrew the brand, that particular line, and the matter was resolved. And so I think it's important that any trade is two-way, and I don't mean simply the movement of monies and goods and services, but it's two-way in terms of understanding the legal, social, and cultural environment in which these exchanges take place, because otherwise, whatever rules you have, they're not going to be effective. Thank you.